We were to be represented in the High Court by Stephen Irwin QC 3 months before the case went to court. I got to meet Irwin in person because mine had been identified as a lead case in the action. It had now been joined by hundreds of other ex-servicemen. Among them, ironically, were 40 or so of the lads who'd been aboard the Sir Galahad. I was asked to attend a meeting with the QC and other members of his team. It turned out to be a rather dispiriting waste of time, and one that completely wrecked my confidence in our case. I was ushered into a meeting room, where Irwin sat at a table, flicking through my files. His reading glasses balanced on the end of his nose. He did not acknowledge me, and I waited for what seemed like hours as he and his colleagues grunted and sighed and plowed through their reams of paperwork. After a while, he looked up and asked me if I had anything to say. Yes, I said. If we lose the case, are you going to appeal? Maybe take the case to the European Court of Human Rights. He cleared his throat. If we lose, then I am afraid that's it, he said. I certainly will not be appealing. It will be over. This, and, rightly or wrongly, his general demeanor did not fill me with any enthusiasm. From that day on, I had a gut feeling we would lose. In the end, it took 7 years for the case to come to court. With the big day rolling around on March 4, 2002, it was scheduled to last 8 months, which gives you some idea of why lawyers tend to live in nice, big houses, though it didn't take anywhere near as long as that. I was looking forward to my big day, to the chance to tell my story and fight my corner. But in the end, I was never even called to give evidence. They seem to have been worried that it may have been too traumatic for some veterans to provide evidence. I can accept that. Everyone is different, but I did not feel that way. As it was, my evidence was rubbished in a rebuttal statement for the MOD by Colonel Graham Smith, my old friend GBH, the former major who had been our battery commander during the Falklands War. He described my statement as being variously inaccurate, exaggerated, and disingenuous. I had to look the last one up. My dictionary defines it as not straightforward or candid, insincere or calculating. In layman's terms, a lying bastard. I didn't have the opportunity to defend myself against that, sadly. I'd have liked to because it was very unfair. We had got a boost the week before the trial started, when it was announced that the former Director General of the Army Medical Service was to give evidence against the Ministry of Defence on our behalf. The BBC reported this dramatic twist as follows. Major General Robin Short, who planned Britain's medical deployment in the Gulf War, is to be a witness in a case against the MOD next week. The 1,900 claimants are making a joint action, which will be dealt with in one generic court case. Many have been left severely mentally disabled by their experiences. They claim the MOD failed to treat them properly for PTSD, a disorder which is common in situations of war and conflict. Madge Jen Short told BBC Radio 4's Today program that soldiers should have had better support from their former employer. When one looks on an individual case basis, there is no doubt there are many who have been left severely mentally disabled by their experiences and by the way they were treated thereafter, he told the program. I do not doubt that more could have been done. And secondly, there is no doubt in my mind that more should be and needs to be done, even now. We should not have accepted that this was normal. We should have looked at it then and thought, what should we be doing to identify what we can do to help these people? Madge Jen Short said he was aware of the repercussions of such a senior officer giving evidence against the MOD, but he said he had tried to raise the matter when he was in service and received no support. He added that he believed people currently serving in Afghanistan were being similarly affected. The men bringing the action against the MOD at the High Court served in Northern Ireland, Bosnia, the Falklands and the Gulf. Solicitor Mark McGee of Linda Myers, which is representing the veterans, said PTSD destroys lives. The servicemen feel the MOD did undo enough to educate them or to treat them when they de-developed PTSD, and as a result, their health deteriorated. And they don't have much of a life, he said. The MOD said that while it could not comment on the court case, it recognized that some members of the armed forces did suffer stress after traumatic experiences. A spokesman added that the department had a duty to ensure that they received proper treatment, and if they did not, they may be entitled to compensation. I don't know about you, but to me, that sounded like a nail in the government's coffin. Sadly, my optimism was short-lived. On May 21st, Mr. Justice Owen ruled in favor of the MOD in his judgment. He said, "It has long been recognized that combat may result in psychiatric as well as physical casualties. The infliction of shock and extreme stress on an enemy has been a military objective throughout history. War and warlike operations inevitably take their toll, both physical and psychological." That didn't mean, apparently, that those in charge needed to give much of a toss about the people at the sharp end. Linda Myers issued a statement afterwards. The claimants volunteered for a life that they knew might mean combat and conflict and exposure to the shocking events of war. They willingly accepted the risks of their service, but they relied on the MOD to care for them properly. As the MOD themselves put it in their Claims Annual Report 2001 halves, this litigation is not about the validity of PTSD as a psychiatric disorder. nor is it about soldiers unjustifiably suing for being exposed to traumatic incidents while serving in HM forces. The claimant's case is that PTSD is detectable and preventable, and that proper systems would or should have achieved these objectives in the vast majority of cases. The court in this judgment accepts the reality and severity of the psychological injuries of war, but the result of the trial means that only a fraction of the soldiers, sailors, and airmen we represent will be able to recover compensation. Many will not, because the court found that the MOD can take advantage of a statutory immunity that applied up to 1987. Others cannot recover because of a further historical immunity, which the judge has found still applies for things done well away from any live military action. While the judge found there was effective treatment available during almost all of the period covered by this litigation, he did not find that the MOD had a duty to identify sufferers so as to be able to treat them. We are very disappointed by these findings. The clear implication is that the onus was on the individual to make known their own suffering, even where they were untrained and ignorant of the nature and cause of their problems. We are also dismayed by the findings as to what the MOD actually knew and what they should have known about the long-term psychological consequences of war, which often do not surface until long after the shooting has stopped. These consequences include post-traumatic stress disorder, depression and anxiety, often accompanied by alcohol abuse, unemployment, family breakup, offending, homelessness, and even suicide. We believe that much of the evidence in the case, and in the documents we analyzed, shows that long-term consequences have been known about for many years. We believe it was also revealed that the state of British military psychiatry was woeful during the 1970s and unsatisfactory in the 1980s and 1990s. That has been reflected in the judgment only on some specific points, where the judge has found the MOD were in breach of their duty of care to the men. Those points are important, but not nearly wide enough. The judge conducted this trial in an extremely courteous way. In particular, he showed great kindness to many distressed witnesses who still suffer in their minds from the effects of war or terrorist action. We are grateful to him for that. But we cannot accept that some of his most important findings as to what the military should have known and should have done are correct. Taken together, we believe these findings have the effect of relieving the military of responsibilities it is its duty to bear. We are therefore considering an appeal. Sadly, this was the end of the case. If you enjoy this, please like, subscribe, and comment. Read A.A. McNally's book Still Watching Men Burn: Fighting the PTSD War.